to thank you very much for being a part of the symposium, and
Yes.
looking forward to for your presentation and discussion. But of course, what is going to happen is you are going to tell us about the symposium, and then you're going to tell us about yourself. Is that all right with you?
Yes, very much, sir.
Yeah. So what is the symposium about?
Of course, the symposium is about mediation, about colonization, about decolonization. At first, when I saw the caption of the symposium, that colonization, decolonization, and mediation, I couldn't get the link at first. I couldn't get the link of how decolonization and colonization meets with mediation. But then I noticed the fact that the truth of the matter is, even in the pre-colonial time, this practice of mediation, even other forms of alternative dispute resolution, they have been with us. So I now feel that what is the import of colonization on the mediation practice that has been on ground? So I feel that is, I now connected the dots that, okay, maybe that is the process. And I think we should, this kind of symposium should not stop, or should be encouraged the more, because day in, day out, we are losing the tradition. We are losing that tradition in which we had before the colonization and after colonization as well. And because of the fact that colonization has come and it has introduced certain new ideas and certain ways of life to us, and one way or the other, we tend to acclimatize those new practices, those new ways that colonization has brought to us. We tend to acclimatize it with our own, and most of the times they don't work hand in hand. Most of the times, our own form of mediation. Let me start. Our own form of mediation before colonization at all is that at the end of the day, parties will go out there smiling with each other. And they are not all these two tiers form of mediation. It can even be family head mediating issues among the clan or the community. But nowadays, even before you mediate certain things, you'd still need to go to court first. It is now the court that will now introduce mediation for you, but the case must have been in court at first. So these are the things that, why can't we go back to our own pre-colonial times and embrace this culture rather than hinging on the institutionalization of these processes that is results? I must say most sincerely that the colonization has come to institutionalize practices. Yes, in the core and the beautiful practice in our own form of dispute resolution. See, the truth of the matter is, there is a famous saying by one of our senior lawyers here in Nigeria, Femi Falana, senior advocate of Nigeria. He said that dispute resolution itself, as it is, that the famous alternative dispute resolution that we call it today, can be traced to Africa and other indigenous pre-colonized countries, third world countries, so to say. India is part of them, Ghana is part of them, the list of Pakistan and all those countries, they are part of them. That in our own case, it is called African dispute resolution, because the only one that we know before colonization at all is this form of dispute resolution. So I think this symposium is a knock that we still need to revitalize and regain the strength that we have in our own form of dispute resolution. And then about myself.
Yes.
About myself. Well, as I think everybody can see my name, anyways. My name is Wale Adeagbo, and I'm from Nigeria. I'm a legal practitioner in Nigeria, and then I am enthusiastic about dispute resolution, litigation, and the truth of the matter is, I'm always encouraged that a society with peace, a society with peaceful and harmonious coexistence is a society that can move to its state of development as fast as possible. Yes, the truth of the matter is, whether we like it or not, chaos will be with us, conflict will remain with us. But I am always encouraged, I'm always motivated to be a source of happiness, be a source of development to the society by giving my all in resolving disputes in the most peaceful manner. So since my years of being called to the bar, I've engaged in series of cases. I've engaged in series of cases, but I realized that litigation as it is, doesn't tend to go to the root of the interest of the parties, but alternative dispute resolution actually does. You just go to court and then feel like issues are arranged. No, litigation is based on evidence adduced and pleadings. But alternative dispute resolution, on the other hand, goes to the root of the interest. And once the interest can be seen and be resolved, I feel that should be the best form of resolving disputes. So these are the reasons why I'm always enthusiastic about dispute resolution, and then it has been good. Although my years in mediation, they are very little, they are minimal. I was certified as a mediator in 2021. So my little month of practicing as a mediator is not, as a certified mediator right now, is not really long like that.
But Wale, whenever you speak about certification, then I'll give you a whole lecture on that part. So for me, look, certifications don't matter. It's the mindset. It's the mediator mindset which is required. That's all that's required. Everything else falls around it. And we will discuss this aspect of connecting colonization and certification, but I won't do it right now. I'll do it later after we've had a discussion with you. Because the other thing is, because we use alternative dispute resolution so easily, but actually, of course, arbitration is the same as litigation. There is no difference there. It's just that we need that. What I started calling it is amicable dispute resolution. I want to call ADR that. So that is how I look at it. But please, how are you looking at the colonization part of it in Nigeria? What have you, you've very nicely spoken about the traditional part of it. I think we need to dig a little deeper into that also, to see, was mediation happening or arbitration happening, and to distinguish between the two. That's also important.
So if I get you right now, you want me to discuss the aspect of colonization, whether mediation was happening then or not?
Before, yeah. If we can go a little bit into the pre-colonial times, and then we see how it changed, and the mindset, the conditioning of the mind, and things like that.
Okay, now, there is a famous saying in this part of the world that you cannot go to court and still maintain friendly ties. And this one, it was introduced because our people did not know anything about court processes or court proceedings. But they saw, after the introduction of court system, they saw the fact that people no more got friendly again, despite the fact that they were neighbors, they were friends. After they go to court, definitely the friendly ties began to hit the wall. So the point is this: we Africans, we believe so much in unity and one family. So if we believe so much in one family, we believe in one voice as well. And definitely if issues arise among parties, among families, they tend to settle it in a way to maintain such unity and to maintain such harmony. And the mindset of the people is that once issues arise, they want to settle it in the most amicable manner as much as possible. And then they have given the authority of those settlements to either the family head or the head of the community, also at every point. Now, the mindset is this: they believe that after they have tried or they have attempted to settle issues between themselves, the next line of action is to get to the family head or the head of the community. And whatever the head of the community suggests, of course, it's a suggestion. Whatever the head of the community suggests, they believed that that should be the end of the matter. Now, the British came. Because of the fact that there were language barriers and they did not understand most of the things that our people back here were saying, and they didn't understand the system fully well, they introduced the court system. And most of them are based on commercial issues. The commercial dispute, this so person was supposed to give another person these bags of cocoa, or bags of yam, or bags of beans, or any farm products. But the other person has now turned it down. So the principle of contract came. And then they noticed that the principle of contract in our own understanding is that we need not even pay money for transactions. You can barter trade, so to say. Your bag of rice and your bag of yam, you can trade it by barter. And then these people, the British people, saw that they were not really commensurate with each other. They now said, okay, come. This issue, let us settle it amicably. Now, they introduced the fact that if you have any complaint against any person, make sure you go to the there will always be a British representative in that community. Go to the British representative. They jettisoned in one way or the other the existence of the family head, the existence of the head of the community, in which they were the roots to settling disputes. So they jettisoned it. And then the British came, of course, they didn't know the practice of settlement of disputes back here. So the things they will say is that you have to make a person has to speak for you on your behalf. Maybe there were not much lawyers then, but there are these skilled people that can talk on your behalf. They are very skilled in talking. So those people were the ones that will now talk on your behalf. And the truth of the matter is, nobody can say your mind more than you. Nobody can speak to your mind more than you. Nobody can speak to your interest as you will do. So now, the chain of transmission of what happened is getting lost one by one. Now, the other party too will have a representative who will speak on his behalf. And this now led to court system, kind of. Then the parties will submit, and then the British representative will now give his verdict. This verdict will be given, and it will be given the force of law. And of course, this is without the consent of the defendant. Because of course, it is the complainant that only consented to be bound by the decision of that British representative. So it means from the beginning, ab initio, the defendant did not even have consent. The defendant did not even have the mindset of going there. So little by little, the friendly tie that was in existence before that case they started to be dwindling. little by little. So the mindset of our people before decolonization, yes, it was smooth. It was the mindset of harmony. It was the mindset of making sure that disputes were resolved amicably. And then upon the introduction of the court system, people's mindset is like the highest bidder and the person that can hire who can speak more on their behalf. So this, in fact, led to the practice of law in a bit. So the mindset shifted from I can win even if I do not have a case, because that is the law. It is logic. If your case can follow logic, the law does not concern itself about the interest that you have. Once it's on technical basis, you can win on technical basis. And that is ruining the coexistence that we are having, especially in countries like, in a country like Nigeria, which we have various ethnic groups. So our coexistence, by virtue of this introduction of court system, has not done good to the mindset of settling dispute, in the aspect of settling dispute in Nigeria.
No, I think you really put it nice, stepwise as to what really happened. And that's exactly what we need to touch upon. This aspect of how step by step the colonizer got in and created that divide in society. Because the whole idea being, let's divide the society, come to me. I'm the one who's going to be able to decide for you. So taking away, that's really important. So that's how it is. But then, first of all, of course, that was the colonizer. And then, like you said, creating this whole category of lawyers and that. But what happened after, for a moment, we'll come back to this, but what happened after the colonizer left? What did you see in relation to the system that the colonizer gave? Are we looking at, how did things go on from there?
Now, thank you very much. Now, after they have introduced their system, of course, for long years, for more than 50 years, people's mindset, the first point of contact would never be on mediation. The first point of contact would never be on alternative dispute resolution. In the first place, why do we call it alternative dispute resolution when this is even the best form of dispute resolution? So from the word alternative dispute resolution, you know that the mindset of people does not go to it at first. So it now changed. The point is that court system now became the preferred dispute resolution, or the preferred form of dispute resolution. So anything that happens, to the extent that a little thing or a little issue in a marriage, the first thing that any party inside that marriage will think of is to go to the court, go to the court, go to the court. If a party, a contract between two parties has happened, the first point of contact to do is to go to the court, go to the court. So this has erased, and they have succeeded. They succeeded, truth be told. They succeeded in erasing totally the immediate form of dispute settlement that we used to have before they are coming. So court system was the first point of contact, to the extent that, I will make mention of this, to the extent that the Marriage and Matrimonial Causes Act and the Matrimonial Causes Rule that we use today in Nigeria, they date back to 1960 something, 1950 something. And those are the colonial periods. And then inside this Matrimonial Causes Act and Matrimonial Causes Rule, it states that before you can refer a case to mediation or dispute resolution, that case must have been brought before the courts. So which means the first point of contact in dispute will be the court system. And this, unfortunately, we have not changed this law till today in Nigeria. And I'm not sure, but I want to assume, and I may be wrong, that the countries like Ghana, countries like Libya as well, they have this set of rules, and which is not supposed to be. Marriage is something that is so sacred that we should guard it in any way that even before we reach courts, before we can reach a court to resolve the dispute, it must have been a very serious issue in the first instance, and then we must have exhausted all the local remedies that was available to us before we reach court. But unfortunately, that is not the issue. So the mindset which they succeeded in doing is that it has shifted from mediation or alternative dispute resolution as the first point of contact to court system. And since then, everybody started imbibing in it, and that is it.
Because I think the point, Wale, is that because like the colonizer basically wanted dispute resolution to be in their control. One, of course, their institution, and we will decide, and also keeping that discretion there because the colonizer's man should not get convicted. So keep that discretion and keep that whole system going for that reason. But what we have to, of course, let's have a little competition. What is the oldest act in Nigeria? What year is the oldest act?
The oldest act should be 1880 something. Yes, the oldest.
Okay, so we won. We have our oldest is the Indian Penal Code, which is 1860.
1881, yes.
1860, 1860. So you can...
of General Application. Statute of General Application, 1881. And inside the Statute of General Application, you have so many laws like the Young Persons Act, and then some other acts like that. But the oldest of them all dates back to 1881.
And imagine, I'm saying 1860 is the Indian Penal Code, which we know about. We have so many other legislations which we continued when this, of course, our government now is doing away with thousands of them. I don't know how many different acts were made. But look, important part what we have to look at is the fact that we took that whole structure. With Nigeria, you've kept it to the level of wearing the wig also. We don't wear the wig, we wear the gown and everything and the band, but not the wig. You've kept the wig also. So why has that happened? We'll have to get into the basic aspect of that. Because if you want change and we want mediation to be an aspect that people look at, first you have to understand why that structure was retained, and if you have to, I'm not saying you will be able to dismantle it, but look at it from various angles, like you said, in terms of marriage. Are we looking at it because the colonizer definitely got its own moral values into the law and wanted you to go by that? And of course, the religious aspect, all those things. So I think we need to get into the aspect of why in decolonization also the same thing continued. And is it that conditioning of mind? Is it, how are we going to change it? That's, I think, the most important thing. How are we going to change that part? Or is it going to change?
Okay, by the state of things, for now, in my country, I don't think it will change. Then you ask me why. The reason is this: any single legislation that our National Assembly here wants to make, they do not tend to have an independent mind of sitting down and think about the realities, the social realities of the country in drafting the new legislations. Of course, we have new legislations, I agree. But those new legislations, they are either copied directly from the United Kingdom or any other country. So the factor of not having independent mind in factoring out the peculiar nature of the country, the social realities into the new act, I feel that one will go a long way in determining whether we are ready or not. But of course, as a matter of solution, to this menace is that we young lawyers coming up, the young generations coming up, I feel we have a lot to do, in the sense that whether we like it or not, in the next 20 years, in the next 30 years, the old voices will wade away. That's the truth of the matter. Then the new voices will start coming in. But the challenge that we are having is that there is very little, very minute chance or opportunity for the young voices to thrive in the country. So the old voices, the older voices, they are so loud to the extent that no matter how loud our own voices are, their own tend to override ours. But then we'll keep talking about this, that the only way we can move forward is to those laws that are not in conformity with the reality of the country, let's jettison it, let's do away with it and institutionalize our own. That's the pure thing. But one thing that has made it uneasy again is this in Nigeria, is this. The Constitution of the Federal Republic of Nigeria, 1999, fourth alteration, has made it difficult. Because we need to change the Constitution in order to make effect in so many other laws. If I'm right, I think section 300 and something of the Constitution, maybe 315 or 318, I'm not sure, says that any law that is in existence before the coming into force of the Constitution should be and shall continue to be part of the laws of Nigeria, even those laws that we don't need. Even the laws, so that's why you'll be amazed that till today we are still quoting 1881 Act. For God's sake, 1881 Act should have, of course, you would meet the reality of 1881, but this is 2022. So many things have changed, and this 1881 Act, they were promulgated or enacted without having the reality of Nigeria in check, and without having the reality of the mindset of people of Nigeria in check. So why, as a form of decolonization process, I think, of course, some laws are good. I agree, but those laws that do not totally meet the reality of our culture, the reality of our tradition, the reality of the values that we hold, I feel they should be either changed, jettisoned, amended to meet the realities of our own culture, values, and tradition.
But I think, Wale, what we have to look at is that, of course, the colonizer could rule over a country because of that whole structure that they created in terms of the law and the judicial system. And the people who came after that, who took over from them, I think realized that this is the best way to rule. This gives us total control. Would they want to give up on that? That's, I think, the question there. Would they come up with a structure where the people have more of a say?
Well, I think if that is not impossible, it will be very hard. And it is because of the structures, because of the institutions they have placed strategically for us. I feel Nigeria is the only British colony that still practices presidential system of government, I want to believe. Now, even in India, it is the system of government that they gave to India that India still practices till today. That's the funniest thing. I think we are not ready, or we have in our mindset thought that the British way of ruling will remain the best. Of course, the British way of ruling, or the colonizers' way of ruling, is the best for them because of their history, because of their own values, because of their own tradition, which are not in all fours with our own tradition, with our own culture, with our own values. So I feel it is the acknowledgement of our own values that should come first, and not thinking that the values of one place is higher than the values of another place, because this issue is an issue of mindset. Imagine that we want to create a law, we need to go and consult people abroad, people that do not know anything about how your people feel, people that know very little about your history. So it is saddening that, well, we can do it, but to be honest, it will be hard. It will be hard.
So basically, the concept is that the mind is colonized, and the mind is not getting into decolonization mode. That's what the problem is.
Practically, we are not being colonized, but psychologically, I think it is still there.
Definitely, because I'm telling you, the thing is that we'll keep talking about it, but because the structure suits the person who rules, that's the whole structure. Like even like let's say our civil procedure code, I keep giving this example, is 1908. Of course, we got that's 1908. We got independence in 1947. So you kept that structure because of the discretion it gives you. That it's the judiciary, the kind of discretion that civil procedure code gave is because it suited the colonizer to give that. Because finally you want to show that we have the structure of law, but in it all the loopholes, all the discretion, everything needs to be there, so our guy doesn't get convicted, our guy can go free whenever we want him to go free. So I think that is something which kind of continued. I mean, that's how I look at it in all colonies, because I think that is what the people who came after that realized, that let's just keep this. That's what I'm looking at, because otherwise, like you said, you have to in a way do away with everything and re-look at the entire way that you want to look at dispute resolution. Of course, everything other thing we won't get into, just the aspect of dispute resolution, just that thing. Because the first thing, like you said, about the lawyers coming in and they being created as a layer between the people and whoever is going, I mean, of course, in that case, of course, someone deciding. So I think that layer itself we have to question, although we are part of it, we are part of that layer of lawyers that have been created. But is that layer really required? Like you were saying, that the person whose matter it is the best person to talk about it. So that
Yes.
part of it. So is that layer required? I think that also we need to question, whether the concept of lawyers itself, has it done any service or it's doing disservice?
Okay. There are two things now. There is facts on one hand, and there is law on the other hand. With the reality on ground, with the realities on ground, of course, the parties, the litigants, or any party to this dispute, they know the facts. They know the true state of the facts. But lawyers have been trained to know the law and then apply those facts to the law that they know. So in this real sense, parties may know 100% of their facts, but they do not know how to drive in their facts to the law and then make it admissible for court. If perhaps it is possible to do away with lawyers, there are so many cases that will die on arrival. The truth of the matter is, we cannot do away with lawyers as it is. That's the truth of the matter. But I just want to encourage as much as possible that basic knowledge of law, having basic knowledge of law should be, how do I put it? Having basic knowledge of law by parties. Okay, no. In alternative dispute resolution, if a party even does not know the law, the person sitting over that particular thing knows the law and then will aid the parties in putting in the necessary things, the necessary application of law into the facts. So the work of a lawyer is that just to apply the facts to the law. So I will suggest one thing, that why can't we make it a lawyer party thing rather than a lawyer driven process? Because the truth of the matter is, it is lawyers that will do the entire thing from the beginning to the end, except maybe when the parties are called as witnesses. And when parties are called as witnesses, the truth of the matter today is that they either have time within which to say their evidence in chief, or they have page limits when they want to state their written statement on oath, they have page limit. All those kind of limitations should not be. I will suggest that parties should come to fore without any limit, without any limitation, to state their facts. That will be their own function. Then lawyers, the only thing that lawyers will now do is to apply those laws to the fact. Somebody may argue that that is the practice, but I say no. No, in the sense that a party will just, the lawyer will be the one to help the party write, type the written statement on oath, which may in most cases, do not, in the most sincere part of it, do not represent the interest of the party. So I feel rather than we saying lawyers should do the entire thing, parties should state their own facts by themselves and then be guided by the lawyers. I feel that would be best.
Look, the way I'm looking at it, like you said, that be someone who knows the law. And here we are questioning the law itself, whether that law itself should exist or not. So the complexity of law that has been created. Look, let's look at even the arbitration and I don't know, you've called it the arbitration or the Mediation Act or the new acts that you've come out with, the Mediation Act that has come out. Now, how complex is it? I don't know whether it's got passed by the, I mean, has the president given his assent to it or not? I don't know whether that has happened or not.
It is called the Arbitration and Conciliation Act.
The new one that's come in. So I'm just saying that the new one also finally makes it a little complex for a layman. I'm saying, why are we not creating laws which are simple for someone to understand? And on the other end, if fair, reasonable, just, equitable people sit together, whatever they come to in terms of their understanding, that should be the law. Why should you need a lawyer to explain the law when the law itself has to be fair and just? So I'm saying that the whole concept, the way it's been structured, make the law complex so that the layman can't understand it. If the layman doesn't understand it, you'll need a lawyer to explain it. And once you've reached a lawyer, you've reached the court. That's it.
Let me make this point. Although this is not about mediation or the act on mediation, there's this new act in Nigeria, Electoral Act of 2022. Of course, the members of the National Assembly, they made amendments which were quite all right. These amendments, people have been longing for it so much. People are longing for it, but it came in at the right time. But the problem is, even the amendments that was made, the legislatures themselves do not know that they are shooting themselves in the leg. They themselves do not understand the law they have passed. And interpretations now came to court and they'll be saying, you are no longer a member of the legislature by virtue of this thing if you do not participate in this process and all. You'll be like, oh my God, this is the mistake that we have made. Even the makers of the laws. So that is even the first point of the complexity. And then on this same section of the law, you see conflicting issues, conflicting decisions that, okay, no, it is pre-election matter. No, this is not pre-election, it is pre-election or pre-primary. So the issue is, once laws like that, if the lawmakers themselves do not know it, how do you expect ordinary laymen?
Exactly.
So it is only the lawyers and the courts that can give it. And even the courts are giving contrary decisions, conflicting decisions on the same section of the law. So, like you said, the system has been done in a way that the law will become more complex for a layman out there to comprehend in the first place. So they cannot even know anything. So having basic knowledge of it, they will require the service of a lawyer in order to be able to even interpret it to them. And then the court can give their final verdict on such.
Because look, because the same thing, of course, let's just look at it only from the mediation perspective.
All right.
The countries are legislating and coming out with complex laws. And like I said, I mean, for me, that has to be so simple, because finally we don't want them to go to a lawyer to understand the law on mediation. Because once they've gone there, we've created that chain. Like I said, once you've reached a lawyer, yes, the lawyers themselves needed to be more responsible and not push people into litigation. That should have been their role, but that role is not what they lived up to. So today, if a person comes to a lawyer, the process of sending a notice to the other side by itself spoils the relationship. So your relationship is gone because of the allegations and everything made in the notice, and because that's the requirement of the law. Because yes, if you have to file something, you have to give that notice to the other side. So you've already started that chain. So I want to keep the people away from lawyers, and if I have to keep them away from lawyers, the law has to be simple. And but the colonized mindset, it doesn't understand, let's look at simple language. The language also has to be complex. We take this from something which has already been created. Language, those words only the lawyer can understand. I think all those things, I think we also need to address, Wale, because those areas are also important. From let's just look at it from the mediation perspective. Let's just look at it. What is the kind of legislation that you would look at if you wanted a legislation that you were making? Wale was drafting a legislation on mediation. What would it look like?
Okay, first off, it will look like this, that there are some matters that shouldn't even see the four walls of the court. One of such is marriage. That they shouldn't even see the four walls of the courts, whether it is a statutory marriage or customary marriage. Before they can see the four walls of the court, there should have been lines of things that they have done, and they must have exhausted the local remedies, the real remedies. So what I would do is that before you dissolve a marriage, before you go to court at all, make sure that parties, like a compulsory thing. Once it is statutory, it will be compulsory. Once it is made in the statute, forget it, it will be compulsory. And once you don't follow the processes of the statute, then it is gone. So I feel there are some matters that shouldn't even see the four walls. One of such, like I said, is the marriage. Secondly, businesses, commercial issues. Day in, day out, parties will transact, people will transact, businesses will thrive. And it is this business that move the country forward, that move the economy of the country. If that is the main core of a country's economy, then why are we wasting so much time in court for 11 years in determining whether somebody is right or wrong? So the first thing is that mediation should, although it is not a compulsory step, I think it is the compulsion part of mediation or any other dispute resolution that is making it like this. So if mediation can be made sort of compulsory and mandatory for, or in commercial issues, in commercial disputes, and parties must have been seen to have actually mediated or gone through alternative dispute resolution before they can see the four walls of the court at all. I think that will help. And then what will help actually, another thing that will help is this, that once those issues of marriage, issues of commercial disputes are made to be compulsory, to go through mediation compulsorily, then the High Court should be the last resort. Not like once you get to the High Court, you can go to the Court of Appeal, then you can go to the Supreme Court. That one will make the issues linger. Imagine a company fighting over the issues of tax and all, and for 11 years, they are still on that issues of tax. And the truth of the matter is, once that kind of thing is in court, parties will maintain status quo. Once they maintain status quo, businesses, whether you like it or not, they will hit the rock in a way. They most likely hit the rock. Then it is affecting the economy of the country. Then it is affecting the development of that country. So, but mediation is just for parties to talk the way out. Yes, issues have arisen. we have disputes, we have problems. How can we solve it? That's the only thing. And then let's draft out the terms of settlement, and then let parties go on with it. That's all. I think that's all. So that one will drive the economy. And we wonder why a country like Nigeria is still tagged third world country and we are having issues of development. One way or the other, these kind of things, they affect it. They do affect. So I will make mention of the Tax Appeal Tribunal, Tax Appeal Act. See, this Tax Appeal Tribunal Act, it actually gives the chance of mediation, sort of, or dispute resolution, alternative dispute resolution, sort of, in the sense that you have to write to the authority first that you are aggrieved with the evaluation of your tax. But that 30 days, after the 30 days, they will sit at the tribunal. After the tribunal has given their verdict, you can still appeal. Once you appeal, anything you are not conversant with, you are not satisfied with, you can still further appeal. Excuse me. These ones in our courts, the reality is this: in our courts, whether you like it or not, any case will enjoy adjournment. The only thing that is not affected is electoral matters. So I feel that matters like this, matters like that deals with tax, matters that deals with commercial disputes, they should be given the same importance as matters like elections. Because now, whether you like it or not, in this country, electoral matters will be resolved within 180 days. There is nothing that can extend that. So if these commercial issues, if these tax issues can be given the same pedestal, can be elevated to the same pedestal and given the same constitutional importance as the electoral matters, I feel the country will move forward and the country will develop more than this. Assuming that any matter that has to do with tax or tax appeal should be resolved within 60 days. Yeah. Whatever the court pronounces will be final. And then things will move forward. Parties will know that whether we like it or not, in 60 days we'll jettison with it and parties will go their long way. So it is first, like I said, matters like marriage, matters like commercial disputes should be given, should be mandatory that they be resolved via alternative dispute resolution as first point of contact rather than going to court. And then secondly, matters should be elevated, should be given high importance in giving them specific dates within which they must be resolved. Because the truth of the matter is, mediation is not binding on parties, of course. It's only arbitration that is binding. So if mediation is not binding and then the further result can still be the court system, we acknowledge that. Then the processes in the court system should be time bound so that it will not enjoy adjournment upon adjournment upon adjournment, and then something that is supposed to have been resolved within 3 months still lingers for 11 years or 10 years.
Because Wale, you get a little frozen, but
that's my take.
Because how I'm looking at it is, of course, you said about 11 years. In India, it might be 14 years, might be 20 years. So similar situation we face. How I'm looking at it is that why are we even talking about these commercial matters coming into court? The court today is overburdened. There's a person that you have sent into jail, and the person is innocent up till proven guilty, but is sitting in jail waiting for his case to come up in a court. But you are going out, someone did not give someone 1 million naira worth of goods, so the court is spending its time on that. So either you become so efficient that you can give a person who's in jail. First of all, why would you put anyone in jail? I mean, this is something, again, a colonial concept, that you have a jail. We have to make sure that we have control over you. We can put you into this place and you will be humiliated. So let's do that. First of all, you have to question that aspect itself, whether those jails have to exist like that for an innocent person to be sent there. The other aspect is that should the courts be looking at all these, like you said, family matters or commercial matters? This is a commercial matter between two parties. Like here we're talking about mandatory mediation. It should be mandatory arbitration. I mean, you have to find your judge. Don't come to us. Why should you come to us? Why should the state be looking at it? This is, again, I'm telling you, this is a colonized mindset that the state has to be involved in everything. But yes, if for any, okay, you have from an arbitral award, whether that needs to be challenged or not, how it has to be challenged, and that also comes into court and spends tens of years, 10 years or whatever in the court, then there's no use. So of course that needs to be looked at, how that has to happen, because finally you trust someone to take a decision for you, and then the person, the arbitrator, takes a decision. You go into that chain by yourself. To the court to even come in there, I think we have to question that part. The state and the court have to stay away from, they don't have to get into every dispute resolution, but then the control goes away. So that's one part. But the other thing is, I'm talking about the mediation legislation. Why I was asking you is because I want it to be so simple that the people who are in dispute can choose who their mediator is going to be. Process is totally flexible. No one has to tell them how to go about the process. The only thing that needs to be protected is, if confidentiality has to be protected, without prejudice has to be protected, mediator not being called as a witness needs to be protected. There's simple things to protect, and people will understand in a simple law. And what else do you need from that law? I'm just trying to understand this whole colonization mindset of making a complex law, because I'm telling you, your law is, I don't know, it was simple, but it did not have the teeth. So the settlement agreement was not enforceable in court. That was what your situation earlier was. But today, the law, the act which was sent to the president, did that have teeth or not? I don't know. I mean, I haven't seen what has it come out or not from there. But if that is simple, it's a simple law, and it can get the teeth can be, the settlement agreement should be as good as a court decree. That's all that's required, nothing more than that. I don't know what you think about that.
Well, I feel settlement agreements. Yes, people are bound by whatever they have entered into. They are bound by whatever agreement they have entered into willingly. But there is still this challenge that even that agreement itself, that agreement that you have entered, if perhaps there is an issue or there is a dispute arising from that agreement itself, the only institution you can go to is still the court.
Yeah.
So the system is so is giving is making the entire thing so complex that it will be hard. And it's like this. It's like we have entered an ocean. To get ourselves out of the ocean, we must learn how to swim inside that ocean first. So while we are learning to swim inside that ocean, of course, we'll relearn. And the ocean, of course, we are still in the ocean. So it will take a very long years of practice, long years of experience, long years of understanding our nature before we can get out of that ocean. So I feel I don't want to be sounding pessimistic anyways. I don't want to be sounding, because I believe that it is possible. But the truth of the matter is it will take years. And you made mention of one thing about people being in jail and all. We cannot remove the fact of deterrence. We cannot remove that part of sounding a note of warning to other people, so that they will not, any person that you have sent to jail is doing, or so that other people will not do it. But it has been over abused. It has been abused in this part of the world, so that before somebody is arraigned, of anything, you will first of all use like 2, 3, 4 months in jail in custody before he's arraigned. After his arraignment, long adjournment, and during the process of adjournment, he will still be in custody. So I feel the only way out is that the police system too, they should be trained. Even this, they should be trained in mediation as well. Yes, they should be trained in mediation.
But
And I must commend.
No, please. Yeah. You're saying something. I'll come after that. You were saying something?
He said, I feel I should commend the Institute of Chartered Mediators and Conciliators in Nigeria for doing that. They have been training the security personnel and security institutions in Nigeria that it is not everything that goes to court. It is not every matter that people have complained about that goes to court. Even you as a policeman, we know that you are trained to be a prosecutor. You as a policeman, you can in your mediation training, you can in your dispute resolution training that you have, you can resolve this dispute within among these parties.
But look, Wale,
And
the thing
they have
is,
been doing that.
no, but the problem is that in a way we are accepting again a colonizer's police. The police, the structure that was given to them, when you're saying deterrent on one end, but on the other end, the aspect of creating a jail in the structure that it is. My concept is, aren't you innocent up till proven guilty? How, on what basis are you sending someone? You've already, in a way, convicted the person by putting them behind bars. So we have to question that prison, because that was made by the colonizer. And it is a colonizer's institution. It is the way it was structured was that you are humiliated. That's the whole concept behind it. If you are not, where is the threat? I'm telling you, Wale, finally, two threats are there, which has come from the colonizer. I'll take you to court. I'll send you to jail. This is the threat which continues even today.
At this point, I must state that jail system has actually been with us. I can speak of Yoruba land. I'm very sure of that jail system has been with us even before the coming of the colonizers. Yes, they call it tubu. They call jail tubu in our own language. The tubu is a space of inconvenience. Is a space of inconvenience to serve, so that a person that has been found guilty or is on trial will be put there so that he won't feel convenient while he's still on trial. Although back then, the process of trial, the process of determining whether somebody is guilty or not was always faster than this period. Once the king, so to say, or the head of the community or the entire community sits over it and be like, okay, this person is guilty of this. But before then, you would have been in that tubu, like I said. This is jail, it's called jail. So he would have been there. Then once they determine it, if he is guilty, fine, he's guilty. They will put the normal punishment will be meted on him. And if he's not guilty, he will be free. Within 3, 4, 5, 6, 7 days, he will know his fate. But same is not the process here. Of course, before the colonizers too, there used to be this age grade system in the Yoruba land. Age grade, because they understand that it is young people that have the power, the strength in securing the society, so to say. So it is this age group that will be in the affairs of maintaining law and order. So anybody that is now found wanting of a particular thing, they will be the one to go to that person's house and fetch the criminal, the supposed criminal, the alleged criminal. They will be the one to fetch him. So there is a system of policing. And this is not saying that this age group will be high-handed or they will be wicked in their ways. They will be trustworthy and they will be honest in their ways. And of course, with the process that is coming in now, these police, these age grade people, they don't belong to the king. They do not belong to the community head. They are part of the community, They belong to the society at large. So they are not tools in the hand of the king or the head of the community to go and hunt anybody that is against the interest of the king or the community head. So the only difference between the age group system of policing then and now is that the police now, they are tools in the hands of the head of state or anybody that can control the affairs of the territory. Do you get it? So what they had back then, we had jail system, like I said, and we had policing system. And I feel that is the area of distinction and the area of convergence with the colonizers' system.
Well, yeah, because while Archana is here and Archana's session starts, and we always start our sessions on time. So, of course, we'll actually have to come in, but I'll make one statement before that. I'm saying that what practice happened even before the colonizer came in, and it was something which was controlled by, say, a ruler. And that is the relationship that you had within that structure, that someone was ruling and you were ruled. So colonizer also the same thing happened. Then that system of that ruler we should not take. Today we are supposed to be free, and we should be, it's a people's government as we want to believe. So in that kind of structure, we should question these aspects, because yes, there might have been a place of inconvenience, and like you said, it could be for a few days. But I'm saying, even if there's a threat on you to be able to put in this place of inconvenience even for 1 hour, if something cannot be done about it right there, aren't you in a way convicted by while being innocent? And the threat is put on you, that fear is on your mind. And like I said, these two aspects, I'll send you to jail, I'll take you to court. When these two things don't become a threat, that's the day we'll be decolonized. That's what I believe. And of course, on mediation. But at this point of time, a quick concluding remark, Wale, you can give. Archana has still not put a video on. So if you have anything and concluding remark that you want to give, please.
Well, on my concluding remarks, I must say first that you have really done well by putting this in place, this kind of symposium in place. And then I'm speaking on behalf of the young lawyers and young Africans, young Nigerians, that our psyche can actually change. We can change our psyche, and having a mindset of new country, a mindset of new Nigeria that portrays our own true tradition, our true nature, our true values that we have. Although it will take time, but I must say that this is achievable. And we can do this by making sure that in resolving disputes, let's go back to history. Let's go back to history and see how our forefathers were resolving their disputes. And because, yes, education has come, and thanks to the colonizers, education has come, we can, in our own way, acclimatize and Africanize or bring it home and make sure that it conforms with our own history and tradition. So that's what I want to say. And then I am using this moment to encourage young people, young lawyers, to embrace alternative dispute resolution, especially mediation. And then our psychology should be changed and shift from colonization psyche to a fresh psyche, whereby our past can be seen in what we do in the future, but in an institutionalized manner. So that is just what I want to say. And I really thank you for bringing me here as well. Thank you very much.
So yes, Wale, you and all your young lawyers have to relook at it from a totally fresh perspective. Forget all that structure that you've been given. Look at it totally the way it would work for you. But when you say alternative dispute resolution, for me, it's mediation. Other aspects of alternative dispute resolution, arbitration is the same. It might come under the ADR category. It doesn't work for me. So perfect. So thank you very much, Wale. And of course, thank you for being part of the symposium. We'll have to switch gears and get Archana in, because it's her time. We've taken 5 minutes of her time. Sorry, Archana. Please come in.
No problem.
You can say hi to Archana, Wale, and Wale can say hi to you. Yes.
Hi, Wale. Hi, Vikram. How are you?
Hi.
So